second. You're in the middle of a really bitter divorce. Tensions are super high, right? And then suddenly your spouse drops an absolute bombshell.
Yeah, like a stack of memory cards or something.
Exactly. A stack of secret recordings of your private conversations from, years ago. And you had absolutely no idea you were even being recorded.
Right, which immediately makes you wonder, is that even admissible evidence? Or is it just a massive violation of your fundamental rights?
Well, that's exactly what we are getting into on today's deep dive. Because this isn't just some hypothetical thriller. It's the reality at the center of a pretty sobering 2025 Indian Supreme Court ruling.
Oh, right, the Vibhor Garg versus Neha case.
Yeah, that's the one. So just to set the stage for you, the couple got married in 2009. Then by 2017, the husband, Vibhor, files for divorce in Punjab.
And then the whole thing takes a really wild turn.
It really does.
Yeah.
2 years later, he submits these secret audio recordings of his wife, and they're from way back in 2010 and 2016.
Which, sets off this profound legal clash. I mean, we are looking at the fundamental right to privacy going head-to-head with the right to a fair trial.
Right, and that's our mission for today, unpacking that clash. Because, well, wait a second. If he recorded her secretly back in 2010, how does that even make it into a courtroom nearly a decade later?
It's a great question.
I mean, I always kind of thought marriage was legally considered this sort of locked vault of secrets. Doesn't the law protect that intimate space?
Well, yes and no. Legally speaking, marriage is a locked vault. The law protects that vault through something called spousal privilege.
Okay, spousal privilege, got it.
Right, which you'll find in Section 122 of the Indian Evidence Act. So the general rule there is that a married person cannot be compelled, or even permitted really, to disclose private communications made by their spouse during the marriage.
Because the state basically wants to protect healthy marriages,
Yeah.
right? Keep the vault shut.
Exactly.
Yeah.
But here's the catch. The Supreme Court pointed out that there's actually a built-in exception written directly into Section 122
Wait, really? An exception for what?
for suits between married persons. The privilege specifically does not apply if the spouses are suing each other.
Oh, wow. I see. So because they're actively suing each other in a divorce proceeding, the relationship the law was trying to protect is basically already over?
Yep, pretty much.
So the law is like, well, the vault automatically unlocks. But hang on, you're telling me that simply because they are divorcing, her constitutional right to privacy just sort of evaporates?
Well, that was exactly the wife's argument.
I mean, that seems incredibly easy to abuse.
Her lawyers thought so too. Initially, the High Court actually agreed with her, arguing that admitting secretly recorded audio violated her fundamental right to privacy under Article 21 of the Constitution.
Right, Article 21. So how did the Supreme Court flip that?
They had to balance that privacy right against the right to a fair trial. You have to think about the reality of domestic disputes. I mean, cruelty almost always happens behind closed doors.
Yeah, that makes sense. It's not like you have third-party witnesses standing in the bedroom taking notes.
Exactly. So if the court blocks the recordings purely in the name of privacy, they might be throwing out the only actual proof of what happened.
Oh, I see. So privacy can't just be used as this absolute shield to block relevant evidence.
Right, or to deny a fair trial. When spouses are suing each other, uncovering the truth basically takes precedence over keeping that vault sealed.
Okay, but even if I accept that, surely you can't just walk into family court with some random audio file on a thumb drive and call it a day, right?
Definitely not.
Because in the age of AI and deepfakes, how does a judge even know the recording is real?
They don't. And that's why secretly obtained evidence isn't just automatically rubber-stamped in India. It actually has to survive Section 65B of the Evidence Act.
Section 65B, what does that do?
Think of it as a super strict digital chain of custody rule. You can't just play a file. You have to provide specific metadata or certificates to prove the electronic record hasn't been tampered with.
So you have to prove it hasn't been heavily edited or artificially generated by an AI?
Precisely. So a lack of consent from your spouse doesn't erase the evidence, but a lack of digital authenticity, that certainly will.
Wow. Okay, so this is just a massive wake-up call for anyone going through a divorce. The sobering reality here for the general public is that your private texts, your calls, those bedroom arguments...
They carry absolutely no expectation of privacy once you enter a courtroom.
Yeah, that is a really harsh truth.
It is. And for any legal professionals listening, the takeaway is clear. The Section 122 exception explicitly means you can bypass spousal privilege.
But you still have to pass that digital chain of custody test, right?
Absolutely. Proving authenticity under Section 65B remains completely non-negotiable. If you don't have that, the judge will just toss the tapes out.
It really shows how the justice system is just constantly scrambling to adapt, doesn't it? Like, as consumer technology reshapes our most private relationships, the courts are really just trying to find the truth in the wreckage.
Yeah, I mean, every new device we bring into our homes adds a whole new weight to the scales of justice.
Which actually leaves me with a final thought for you to chew on. If our smartphones, our smart speakers and watches, can capture literally every whisper,
And they do.
right, they do. Does the constant lingering possibility of being recorded fundamentally alter how we behave in our most intimate spaces, even before trust is broken? Or are we all just living in glass vaults now?